Retributive justice. Retributive justice is a type of justice that involves the application of punishment for breaking the law, usually by a criminal law institution. It is a response to criminal behavior that focuses on the punishment of lawbreakers and the compensation of the victim. The punishment must be proportionate for the crime committed. Retributive justice doesn't seek to reconcile or repair, but it solely seeks punishment. And retributive justice is based on the theory of retributivism that says justice is a moral issue and that wrongdoers should face just punishment. Impunity or failing to enact retributive justice is immoral on moral grounds. Depending on the justice system of a particular country, the punishment may be imprisonment, fine, or even death penalty to those countries that have it. Also, the traditional justice system from the past requires an eye for an eye and a tooth for a tooth, or a punishment that is equivalent to the injury suffered.
Restorative justice is a process through which remorseful offenders accept responsibility for their misconduct, particularly to their victims and to the community. It sees crime as a breakdown of society and human relationships and attempts to mend these relationships through dialogue, community support, involvement, and inclusion, while our current retributive justice system focuses on punishment, regarding the state as the primary victim of criminal acts, and casting victims and prisoners in passive roles. Restorative justice, by contrast, focuses on healing and rehabilitation. The restorative justice process is actively participated by the victim, the offender, or any individual or community member affected by the crime to resolve the conflicts resulting from the criminal offense, often with the help of a fair and impartial third party. Example: victim-offender mediation or dialogue. This is a process that provides an interested victim the opportunity to meet his offender in a safe and structured setting, engaging in a discussion of the crime with the assistance of a trained mediator. Second, conferencing. This process brings together the victim, offender, family, friends, and key supporters of both in deciding how to address the aftermath of the crime. Third, peacemaking circles. It is a process designed to develop consensus among community members, victims, victim supporters, offenders, offender supporters, judges, prosecutors, defense counsel, police, and court workers on an appropriate sentencing plan that addresses the concerns of all interested parties. Fourth, real restitution is the payment by an offender of a sum of money to compensate the victim for the financial losses caused by the crime. And lastly, community service. It is work performed by an offender for the benefit of the community. It is justified in a restorative perspective as a method of addressing the harm experienced by the communities when a crime occurs.
Transformative justice, similar to restorative justice. Transformative justice emphasizes addressing problems in the community. It aims to advance the procedure a little bit though. Transformative justice emerged in the late 1990s as an adoption of restorative justice that sought to address the social inequities and environmental factors that allowed the harm to be done in the first place. Safety, healing, and agency for survivors. Accountability and transformation for people who harm. Second one is community action, healing, and accountability. And the third one is transformation of the oppressive and violent governmental institutions, dominance, and social conditions that promote violence.
Which justice stated a while ago is the best approach and why? The best approach among the three is a transformative justice, because this justice aims to dig deeper and ask the question, how can we also address the root causes of injustices and move toward an even stronger community? This justice utilizes some of the same accountability techniques within interpersonal healing, and strives to use the conflict as an opportunity to address larger sociopolitical injustices. The field of transformative justice is intended to build alternatives to our current justice systems, break generational cycles of violence within our communities and families, and address, reduce, end, and prevent violence from happening. Individuals will be able to comprehend how hurt and violence lead to obligations and needs within communities, and how the response to persistent patterns of violence must both hold those who can harm accountable and promote healing for both individuals and communities. Transformative justice emphasizes the crucial role of community responses to harm, violence, or abuse, while acknowledging the importance and dire need for reform of current criminal justice processes and structures for harm reduction. This is based on the fundamental conviction that there are boundaries to the amount of healing that the formal justice system can offer, and that there may be room for change in our communities through grassroots forces than through the formal justice system.
So now we move on to multilateral treaties. So first of all, what is a multilateral treaty? A multilateral treaty is a written agreement between three or more sovereign states establishing the rights and obligations between these parties. They often result in international conferences or a gathering of nations done under the auspices of international organizations. So what are some examples of multilateral treaties? So first, we have the Convention Relating to the Status of Refugees, or also known as the 1951 Refugee Convention or the Geneva Convention of July 28, 1951. It is a multilateral United Nations convention that establishes the definition of a refugee, as well as the rights of those who are granted asylum and the obligations of states that provide asylum. Second, we have the United Nations Convention on the Law of the Sea, also known as UNCLOS. It is also called as the Law of the Sea Convention or the Law of the Sea Treaty. It is an international agreement that establishes a legal framework for all marine and maritime activities. Third, we have the Rome Statute for the International Criminal Court. It is a treaty that established the International Criminal Court or ICC. And lastly, we have the Paris Agreement. It is an international treaty on climate change adopted in 2015, in which the goal is to keep the rise in mean global temperature to well below 2 degrees Celsius or 3.6 degrees Fahrenheit above pre-industrial levels, and preferably limit the increase to 1.5 degrees Celsius, recognizing that this would substantially reduce the effects of climate change.
Moving on to the final question, what do you mean by international law? An international law defines the legal responsibilities of states in their conduct with each other and their treatment of individuals within state boundaries. Accordingly, United Nations declares international law as part of a domain that encompasses a wide range of issues of global concern. For instance, it can be used to protect human rights, disarmament, international crime, refugees, migration, and problems of nationality. The treatment of prisoners, the use of force, and the conduct of war, among others. In accordance to the definition of international law, it shall also regulate the global commons. For instance, this could also be used in environmental and sustainable development concerns, international waters, outer space, and global communications and world trade. Now, on the role of United Nations in the codification and development of UDHR or Universal Declaration of Human Rights. A strong and unified declaration against flagrant human rights violation was necessary to prevent such violations from recurring. As a result, the United Nations, established in 1945, began formulating a policy to make respecting human rights an international priority. The declaration was drafted by representatives of all regions of the world and encompassed all legal traditions. Formally adopted by the United Nations on December 10, 1948, it is the most universal human rights document in existence, delineating the 30 fundamental rights that form the basis for a democratic society, including the right to be free from torture, freedom of expression, education, and the right to seek asylum. It also contains civil and political rights such as the right of life, liberty, and privacy. Finally, it has economic, social, and cultural rights such as the right to social security, health, and adequate housing. Today, the Declaration is a living document that has been accepted as a contract between a government and its people throughout the world.